The views and opinions expressed by the hosts of this program do not represent the groups that we are affiliated with. Listener discretion is advised. This show is uncensored.
This show is brought to you by the Serious Cybernetics Corporation. New genuine people personalities for your robots? What can go wrong?
The thing you ought to know, I'm feeling very depressed.
I'm Mike Toller.
And I'm Brett Peter.
And this is Don't Panic, McHenry County. And today we are talking about Illinois Supreme Court. I didn't even know this, and neither did you until recently. Illinois Supreme Court, those people are elected every 10 years. It's not a lifetime appointment like it is at the federal level.
That is correct.
So that was interesting, and it came up because I was looking at we've got a case with the township stuff where that's going up to the Illinois Supreme Court to check the constitutionality of that against the Illinois Constitution. We talked about that in the previous episode, but it had something to do with the Illinois Constitution says that you should never make a specific law when a general one will suffice. So we started looking into the Supreme Court stuff, and then I ran into an interesting fellow, Daniel Epstein, who's running for that in the First Judicial Circuit, and so that's in Cook County.
Right. The First Judicial Circuit is only Cook County.
Right.
Then there's 4 other districts after that. That, of course, include the rest of the 101 counties?
Yeah.
So Cook County elects 3 of them every 10 years. Every other district only gets 1. Now, obviously, that's population-based. So
almost as if it's like representative of population. Oh, phenomenal.
Representative voting?
Oh,
yeah.
So when I ran into Daniel's running for that office, I asked him if he'd come on the show, and we actually have him on the phone right now. Are you there, Daniel?
I'm here.
Awesome. So you're running in the like I said, the First Judicial District, and I listened to you talk, and I was very interested in some things that you had to say. So I figured, we've got this little bit of an audience, and give you an opportunity to reach out to some people here in McHenry County, even though they can't vote for you. It's good for them to get an idea for what's wrong with the court and what you're looking to fix, and that was what I was really interested in.
Yeah. So first of all, thanks so much for having me on. I really appreciate the opportunity. And you said it right. I'm running for Illinois Supreme Court in the First Judicial District, which is Cook County. And I'm running to prevent bias and corruption. And just a little bit of background. The Illinois Supreme Court they do more than just decide cases, right? They're the biggest court in the state. That's what they do. But they also can write all the rules of procedure, all the rules of evidence, all the rules of ethics. They determine things like design standards of courthouses, like the physical design standards, which has a big impact on access to justice for undocumented people and trans people and people with disabilities and people with jobs and caretaker responsibilities. They have a role to play in the data infrastructure of the court, in determining who gets to be a lawyer and how an attorney disciplined, and on and on and on. They're like the chief executives of the justice system in many ways. And what that means is they really have the power to prevent certain injustices. So that's really what I want to do. I want to use that non-adjudicative power to change rules and make sure that we're not falling victim to corruption, that we're not falling victim to bad incentives and bias, and that people can even get to the courthouse in the first place, that we're getting access to justice in a positive and productive way. That's really what I'm trying to do. Awesome.
So I just want to make sure I heard that right. The Supreme Court decides the design. So if they're going to go out and build a physical design of the layout of the courthouse.
Yeah. So that's right. So if you go onto the Illinois Supreme Court's website, you can find a document where they determine design standards, and it's not like they're doing like blueprints for the most part. Really, what they're making sure is that the layout of courtrooms are physically placed in ways that cater to justice. But what it also means is, we can make sure we can go beyond that, because we can create design standards that relate to, for example, whether we have digital recorders in courtrooms, right? That doesn't seem like a big thing, but it really is, because actually, a lot of our courtrooms don't have court reporters. You know how when you watch TV, there's always someone sitting next to the judge who's typing away as people speak? Mm-hmm. Yeah. So those are court reporters, and you always see them in every TV show where there's a court, right?
Yeah.
But as a point of fact, in Illinois, a lot of our courts don't have that. You show up and there's not someone there doing that. And what that means is there's not a transcript being produced. That's a big problem because those transcripts are useful if you need to fix an error on appeal. So let me give you an example. Let's say let's say you're my landlord and I'm your tenant, right? And you evict me for a bad reason. And so I'm going to take you to court to challenge the eviction. Well, in a lot of landlord-tenant courts, there's no court reporter. And so we're going to show up and we're going to do our case. And in Cook County, the case that's going to determine whether one of us has a roof over our heads is going to last an average of 100 seconds. Right? That's how long you get, basically, on average.
Okay.
And in that 100 seconds, you might expect that some mistakes might be made. And if so, I'm going to want to appeal and say, let's fix this mistake on appeal.
Right.
And I'm going to try and point to the mistake. And I'm not going to be able to point to anything because there's no transcript. Big problem. What that means is basically I'm out of luck.
So is there no court reporters because they don't have enough people that know that they use like a shorthand, that little shorthand typewriter there. Mm-hmm. So they just haven't had enough people, and then they never bothered to switch to a digital recording.
So it's just starting to switch for the very first time in some courts, but not everywhere.
And I know McHenry County, all of the courts, the McHenry County courts are recorded. 100. In fact,
we have digital since probably I think it was 5 years ago.
In fact, I used to know the guy that sat in the center room that maintained all the recordings. I don't know if he still does that, but all of them are recorded in one room.
Yeah, and that's fantastic, but that's not the case everywhere. And in many cases, what you're expected to do is really one of three things: either bring your own court reporter, like hire a court reporter, which is extraordinarily expensive, or you can do one of two other things, which is called create a bystanders report or an agreed statement of fact. And those are basically where you just write out what you think happened at trial or at your hearing, and try and get either the judge who you're attempting to reverse to agree that that's what happened, or the other side that beat you and has no interest in trying to have their decision appealed to agree to what happened. So basically, it's an impossibility.
That doesn't sound very, very just or fair.
No. Can I not just pull out my cell phone and just record the thing?
No, in fact, I think there's a lot of laws against that. Just recording on your own.
That's right. You're not allowed to.
Well, what the shit? Isn't that a public thing anyway?
No, not necessarily.
Really?
That's right. Yeah, you're not allowed to do it. So but the good news is wiring up the courtrooms with digital recorders is fairly inexpensive, and hopefully we're moving in that direction. But in the meantime, the Illinois Supreme Court is really responsible for, one, design standards that could aid us in making sure that our courtrooms are set up with that kind of infrastructure. But also they oversee something called the Administrative Office of Illinois Courts, which also oversees putting in those digital recorders and releasing the funds that would allow us to do that. So again, the Illinois Supreme Court, everything we just talked about has almost nothing to do with deciding cases, and it's all within the purview of the Illinois Supreme Court.
That's insane.
Right?
Oh, man.
There's more that I've learned about the Illinois Supreme Court in 2 days than I did in 4 years of high school and government.
I don't even think they ever talked about the Illinois Supreme Court in my high school government.
No, I think they just mentioned that there's X amount of justices and these are who they are and this is what you need to know their names to pass the test.
I don't even think they mentioned that. I think they just mentioned, there's a federal Supreme Court. They talked about that, and then they said, oh, yeah, there's one at the state level, too. But moving on. So you kind of assume that it's exactly the same as the federal because they didn't expound on it.
No.
It's very different. And it's different in a number of different ways, too. So the U.S. Supreme Court also writes all the rules for how our federal courts work. But here's the interesting thing. They do that through the authority of Congress. There's something called the Rules Enabling Act, which gives the authority to the U.S. Supreme Court to write those rules. And what that means is if U.S. Congress passes a statute that conflicts with one of the rules that the Supreme Court of the United States writes, Congress's law wins, right? But in Illinois, it's exactly the opposite, because the Illinois Supreme Court has interpreted our state constitution to give it rulemaking authority directly from the Constitution, which means if the Illinois Supreme Court passes a rule that conflicts with a law that our legislature made, the Illinois Supreme Court's rule wins. So the implication of that is that the only way to change these rules is through the Illinois Supreme Court. You can't elect a legislator who is a champion of a rule change and have it be successful, because the Illinois Supreme Court might say, breach of separation of powers, you can't fix this, only we can fix this. So let me give you an example.
But
Illinois,
it sounds like
yes,
it sounds more like that would be a checks and balances. The federal level, there's a check and a balance on the Supreme Court, whereas the Illinois state, the Supreme Court seems like they're answerable to no one.
Seems like that, doesn't it?
Well, except for the voters every 10 years.
Right, but how many people actually pay attention to the Illinois Supreme Court? Who's up? I mean, it seems like one of those things that the average person is just going to overlook. So they wind up answerable to no one.
So this is the best, I think, the best argument for elected judges and justices, because the rulemaking authority rests exclusively with the Illinois Supreme Court. Therefore, it's important that we elect the Illinois Supreme Court. I don't know how far that necessarily goes, but that's kind of the best theoretical argument, I think.
I agree, and I wish that I think that it's definitely something that needs to be brought more into the public light. Because you walk down the street, you ask the average person, "Hey, who's your Supreme Court elected in your district? Who's your justice?" Well, what?
Yeah. I can tell you, I've been doing that a lot, and and I can tell you, there's a lot of people that don't know that we have a Supreme Court. If they know that we have a Supreme Court, most folks don't know who's on it. So that's definitely the case. And my challenge is really to turn this from a low information campaign to a medium or high information campaign. Because one of the reasons that we have kind of holes in these rules or injustices that are able to persist is precisely because a lot of folks don't know where these problems exist and who's responsible for fixing them.
All right. Well, let's start with some of these problems then. What do you say?
Let's do it.
All right. So I'm going to go down your list of your issues here. Let's start with the top one. End cash bail. Why is that a problem, and what can we do to fix it?
Yeah. So the bond is the process that determines where you spend the time between when you get arrested and when you go to trial, right? And you'll go to jail, and then you'll go in front of a bond court, and they're supposed to make two decisions. The first decision is whether you're safe to return to the community. If the answer is no, then you're not going anywhere. You're staying in jail pending your trial. If the answer is yes, then you go to the second decision, which is, what do we have to do to get you to come back for trial? And historically, what we've done is require you to put down cash collateral, right? So we'll say, all right, I'm setting your bail at $100,000. You need to put down 10% of that. And that, in order to get that $10,000 back, you're going to have to show up for trial, right? And so because we have your collateral, we know that you're going to show up. Okay, but here's the problem, which is ultimately what that means is if you're wealthy enough to afford to leave jail, you can leave jail. And if you're not, then you don't, right? It's a massive wealth bias. And that plays out in a series of different ways. One is that it really kind of doesn't make us safer. In fact, it seems like it might be making us less safe, because judges sometimes conflate those two decisions, right? Whether you're safe and to return to the community, and how much money we need to charge in order to get you to come back. And what they end up doing is saying, look, if this is a really serious crime, we're going to give you a huge bail. And if it's not so serious, we're going to give you a lower bail, right? And that's a problem, because what that means is that people with money sometimes can just bail themselves out, even though they're dangerous or even though they're not safe to return to the community. So it doesn't make us less safe. It just confuses the issue. The issue should really just be, are you safe to return to the community? Period, right?
Right.
And the good news is, you might worry, well, how are we going to get you to come back for trial or your hearings? And the good news is other jurisdictions have already fixed this problem. DC and California have already started doing, have basically ended cash bail, and through a series of alternative policies. One of them, which is remarkably successful, and we do it in Cook County too, actually, is we just send text messages to defendants reminding them that they have a hearing. It's remarkably effective, and I wouldn't have believed it until seeing that it's true, but it is true. Text messages work.
One would figure that a warrant out for your arrest because you skipped out on your court date would be sufficient enough to compel people to show up.
You would figure.
Right. Sometimes just this small nudge stuff actually has a really big impact. Sometimes just like little convenient things like texting people or having a person, kind of almost like a customer service rep, a social worker, who can remind you that there's a court date and why it's important. Those things go a long way. If you want to get a little bit more intense, some areas have electronic monitoring, like ankle bracelets. All of these are better than cash bail because it doesn't end up kind of penalizing poverty. So that's a big one.
I get a real quick dumb question. That was something I've always wondered with bail. Why is it that they set the number to like 100,000, but they only need to put down 10? Why not just put the number at 10 and forget about the 10%?
You read my mind. That has bugged me since I was like 17 years old.
Well, the idea is that if you don't show up, then you owe the whole 100,000. It's kind of like it's supposed to be kind of a carrot and stick type thing. But instead of a carrot and stick, it's like a small stick and an even bigger stick. So if you show up and you do everything you need to do, then you get your 10,000 back. If you don't show up, you don't just lose your 10,000. You also owe the other 90,000.
Got it.
Okay, that makes more sense.
And as a side note, the other aspect of this is that people who then can't afford to pay their bail, they're lingering in jail sometimes for years.
Oh yeah.
And I talked to a prosecutor the other day who was prosecuting a case where the case had lingered for 7 years while the person was waiting in jail, right? And during that time, your car gets left on the street, right, and gets ticketed and towed. You might lose your custody or your housing or your financial aid for school, or there are massive collateral consequences for people and families and communities, and it's not really useful.
Yeah, I can
better
just
ways to do this.
I can just imagine the collateral damage, the domino effect that happens from that.
That's right.
It's got to be devastating to the rest of your life, even if you're found innocent afterwards.
That's exactly right. And, there's another aspect to it, which is you actually don't. I actually misspoke. You don't get your $10,000 back. You get 90% of your $10,000, and the county gets to keep the other 10%. So actually, let's say you go to jail, you get falsely accused of something, you put down your 10,000 to get out, you win your case, and you're like, okay, now let me get my bail back. You're only getting 9,000 back. The county's keeping the other 1,000 as a processing fee.
So they're still charging you for being innocent.
Officially they're charging you as kind of like a processing fee, but it's 10% of that 10%. And so there's actually a recent case where they set someone's bail at $350,000, and instead of saying, there's discretion over what the percentage that they have to put down on is. So instead of saying 10% of that 350,000, they said 100% of that 350,000. So the guy put down $350,000, won his case, and then said, okay, now give me my $350,000 back. And they said, here's $350,000 minus $35,000 for our processing fee. And so he was out $35,000. He challenged it.
That's like the convenience fee for paying your...
like using an ATM.
No, I was going to say for paying your electric bill online. Like, whose convenience, mine or yours here? Why are you trying to...
Well, and the concern is that you don't want to create a system wherein the entity that sets the bond or the bail profits from setting a higher one.
No.
Right.
Yeah, no.
You're just profiting from human misery at that point. All right. Now, if you're done with cash bail, I don't think I have any questions. Any more questions, Brett?
No, you actually asked the only one.
Okay. Well, there we go. So guaranteed depositions by right. You got here that 97.4% of felony convictions end without trial. That seems ridiculously high. So I can see a problem there already. What's the fix?
Now, is that just in Illinois, or is that countrywide?
Yeah. So the rate at which cases plead guilty, individuals plead guilty, is pretty high across the country. 97.4% is high even compared to other states. So I think the nationwide average is somewhere around 94, 95%. Don't hold me to that, but it's somewhere around there. And that doesn't seem like a huge difference, but it is. That's basically a 100% go to trial rate difference. That's a really big deal. So it's high everywhere. It's particularly high in Illinois, and there's a cost to that. And maybe I can kind of tell you a little story that which is how I started experiencing this. So I've been serving clients in the Supreme Court of the United States and in courts across the country, and I came back to Cook County to defend a guy accused of attempt murder. And he DNA was at issue, and my job was to kind of learn everything I could about DNA and to mount his defense. And so I read everything I could get my hands on. I hired a forensic scientist to help me understand what was going on, and we interviewed the state's DNA analyst. And what we discovered was scary, which is the state was using a faulty DNA machine. And that's scary because, who knows how many people are hurt by a faulty DNA machine. And, if you watch TV, if you watch Law and Order,
literal faulty DNA machine, like this is the one machine, and we put everybody through it, and it don't work right.
Yeah, so I mean, they have multiple machines, but this one was faulty. I mean, they don't have a ton, but this one was faulty. And if you watch TV, these machines look like magic, but they're calibrated by humans, and humans are fallible. And in this case, they failed to calibrate the machine, and it was producing false results. Right? Big issue. But I was still optimistic because I thought, we're going to go to trial. I'll put the DNA analyst on the witness stand. I'll cross-examine him, and we'll expose that problem. Right? And once we're done with the trial, now that information have been exposed, they'll have to retrain the DNA analyst. They'll have to fix the DNA machine, right? We'll make the world a better place one case at a time. That's why I became a lawyer. That's how it's supposed to work.
Yeah, it seems like that's how it's supposed to work.
That's not how it works.
I had a feeling you were going to say that. Not just because I've heard this story before.
Well, it gets worse because in Illinois, I find out from doing more research, our forensic labs are entitled to extra funding when they produce an analysis in a case that ends in conviction.
So,
and I do a little bit. Yeah, sorry. Go ahead.
So I want to reiterate that one time, just for everybody watching, all our tons of watchers there. So they are motivated to get convictions, even if it isn't warranted in the case, because that's how they get extra funding based on the number of convictions, not on just percentage correct, just number of convictions.
Sounds like getting speeding tickets almost. You grade enough speeding tickets, about 90% of them are going to get hit, right?
Right.
So I never got to ask, and I'll kind of show you how this story proceeds, but I never ultimately get to ask the DNA analyst if this creeps into his thinking or not, for a reason that I'll get to. But what I can tell you is the forensic lab gets financial rewards, not for finding truth necessarily, but for finding guilt, right? That's a problem. But it gets worse because our courts are entitled to extra funding if they convict. Right?
Wow.
But look, I'm still optimistic because I think I'll expose this information at trial too, right? And we'll make the world a better place one case at a time. That's how it's supposed to work. But again, that's not how it works, because what actually ends up happening is we go back into judges' chambers under something called Illinois Supreme Court Rule 402. And in a 402 conference, it's like a preview of the case. The state says, Judge, this is what we're going to show at trial. We say, Judge, this is what we're going to show at trial. And then the judge says, okay, well, based on what you told me, were I to convict, I think an appropriate sentence would be 70-something years. And then you back out into the hall, and the prosecutor pulls you to the side and says, all right, you heard the man, 70-something years. But if you plead guilty, I'll ask for 20-something. Right? And so our client has to decide, do I defend myself and risk dying in prison, or do I take the plea and hope to see the light of day? And he takes the plea. And that ends the case. And what that means is I don't get to put the DNA analyst on the witness stand. I don't get to cross-examine him. I don't get to talk about the bad machine. I don't get to talk about the systemic funding issues. All that information disappears, right? And that's where this becomes a big issue, because if that's how 97.4% of felony convictions end, how much information is disappearing? How many opportunities to expose bad machines or other, really important information are we losing?
Right.
And it solved a puzzle for me. Have you guys ever heard of the name John Burge?
Yes.
He's the Chicago police commander who electrocuted people and tortured people and falsely convicted them.
That guy.
Yeah. Mm-hmm.
Did it for 20 years, right? And I'd always kind of wondered, how does that happen? Just functionally, how does that work? And this is how it works. Because if so many cases are pleading out that nothing makes the record, you can't expose patterns of misconduct. And that's how guys do it for 20 years. That's how, bad forensics persist for longer than they should. And the really interesting thing is we have tools to protect ourselves against those things. One of them is trials. Obviously, we don't do them very much. It's like 1 in 40 felony convictions actually has a trial. But even and we don't do them because 40? They're expensive. Right? Wow. Yeah, right. So, 2.6%. Not 100% minus 97.4% is 2.6%. That's about 1 out of every 40. And but we don't do them very much because they're expensive. They take up a lot of resources, right? And people are like, oh, well, if we start spending money on trials, it'll jam up the whole system. Everything will collapse. Okay, fine. Let's assume that's true, even though I'm not going to go down that road. Even so, we have tools that could help us get information on the record without a trial. And that's depositions, also interrogatories. There's a number of discovery tools that can help us do it. Depositions are where you get sworn testimony on the record before a trial.
Right.
Right? And if we do them in civil cases when money is on the line, but we don't do them in criminal cases when liberty is on the line.
Because I've been part to a deposition before, and it was definitely an interesting experience. And again, it was when there was money, a civil case.
Yes. Same with me.
Yeah, when money is on the line, we have all sorts of discovery tools to make sure that everyone kind of knows what the case is about. Before you go to trial, everyone has a pretty good idea of what we're arguing over and what's going to happen. That's why a lot of cases settle, because everyone is pretty much on the same page. But in our criminal cases, you really find out almost nothing prior to trial. It's very little. You're kind of waiting for trial to figure out what's going on in many cases. Not totally. You get these things called Brady disclosures, but in large part, a lot of the information comes at trial. And if you never go to trial, a lot of that information just never comes out, right? And so we're not developing the information that we need in order to protect ourselves. We're kind of cutting corners to cut costs, but it turns out to be one of the most expensive things we've ever done, because down the road it turns into massive civil rights claims, right? There was just an article that about how we paid like $213 million in civil rights claims just to the lawyers of people making civil rights claims based on police abuse and a number of other things, right? And we pay a massive cost in terms of liberty when innocent people go to prison, right? And safety when we put the wrong people behind bars and the right people and the guilty people stay out. There's all kinds of really serious costs that we pay for cutting corners and not doing the kind of discovery that we do when money is on the line.
And everything you've said sounds really against something that I thought that we kind of believed in this country, is that we rather see 10 guilty people go free than one innocent person wind up in jail. Everything seems to stack the other way. We're just going to throw everybody in jail and let God sort them out.
Yeah, we have the presumption of innocence, and we have in criminal cases you have to find someone guilty beyond a reasonable doubt. But then when you kind of go an inch below the surface, the tools for you to be able to prove your case are really limited. And it's some of those kind of hidden tools that are really critical in making sure that you actually have a fair shake when it comes to trial.
Yeah,
so we can fix that. We can fix that, but only the Illinois Supreme Court can do it because that's something that can be that lives in our rules of procedure and our rules of evidence. And again, that's the exclusive authority of the Illinois Supreme Court.
I'm sitting here in my mind, like it's like that GIF with mind blown. Like, this is insane.
It's happening. You don't really think about it, but then it's said out loud, and you're like, wow.
Yeah, you're like, because it's always sitting in the back of your mind, and you feel like it's some kind of conspiracy theory. Mm-hmm. Then somebody says it out loud with the credentials that you have, and you're like, wait, so that's actually real. Oh.
Yeah. Yeah, I mean, I kind of felt the same way when I first started learning this stuff. Speaking of gifts, have you guys ever seen Zoolander?
Yeah. Mm-hmm.
Where Mugatu is like, I feel like I'm on crazy pills.
Yes.
Yeah. That's how I feel sometimes when I read this stuff. But it's true. It's actually how it is.
Man. You know what? It's just, you covered like 3 of your points there too, because you talked about the compensating courts for convictions. You stopped about it. So you are efficient, sir.
Well, it's all linked together, right?
Right.
So, and it's all linked together for a number of reasons. One is because this is not just, these aren't just ideas for me. I mean, these are ideas that came from lived experience, right? These are real cases and real people that I was representing who were being hurt in ways that I think are preventable. And so, as much as these are kind of abstract concepts and rules and just words on a page, I really want to emphasize that part of the reason I have a really serious sense of urgency is because I know the people who were hurt by it. And I had to talk to them and their families and explain the stuff to them.
You've been on the trenches, and you want to champion it, is what it's sounding like.
Right.
Absolutely. So these are things that all kind of weave together in stories and experiences.
So I'm going to jump ahead because it's kind of tied to what you were just talking about, because I want to hear I want everybody to hear what I heard the other day when we were talking about this, and that's to stop the pseudoscientists.
Oh, please.
Yeah. Oh God. So
it's not the pseudoscientists you think, man. Seriously. What? This is crazy.
This isn't Dr. Oz.
No. You get ready for mind blown here.
Okay.
This is insane.
Yeah. So where do you want me to start? Do you want me to start in 1690s, or do you want me to start in modern day?
Just hit modern day. Hit the modern day pseudoscientists. Okay, so this is insane.
Yeah. So I represented some people who were put behind bars based on what's called bite mark science. Sometimes it's called forensic odontology, and this is a technique that is used to look at a mark on a body and determine whether it's made by human teeth, and if so, whose teeth made it, right? So in other words, basically you get a body at the medical examiner, and you're trying to look at an injury on them and figure out who done it based on a mark on their body that may have been linked to a bite, right? And for years and years and years, these bite mark experts would say, okay, I looked at the mark on the body, and I can tell you that the suspect's teeth are consistent with that bite. And based on that, a lot of people went to prison. And years later, basically in the last few years, now that research has started to be performed on this technique, we're finding out that in best case scenarios, they're accurate about 2% of the time.
2%. And Brett is holding his head. You can't see him right now, but he is holding his head.
Yeah. So this is the reason, one of the reasons that these guys can get on our witness stands, and by the way, they made a considerable amount of money doing this. One of the reasons that these bite mark experts have been able to get on our witness stands is because there's something called an expert admission standard. They qualify as expert witnesses based on this standard. And in Illinois, we have a standard.
I've gone through something like this. I've officially became an expert in the automotive industry 4 years ago for something similar to this.
Oh, interesting.
Yeah.
Okay, so
I've done it for IT as well.
There you go. So you can tell me if this resonates with your experience. I don't know if you did it in Illinois State Court, but if so, you may have been required to show that you are using a technique that is, quote, generally accepted in your field.
Yes.
Mm-hmm.
Yep. And that seems innocuous, except when you really look into it, what you realize is people like tarot card readers use techniques that are generally accepted in their field, right? But you wouldn't want a tarot card reader to be an expert witness in a case. In federal court, you have to prove that you're using a technique that's reliable. That's a much better threshold, right?
I agree.
Yeah.
Right. And these bite mark experts, they may have been using a technique that was generally accepted in their field, but they certainly weren't using one that was reliable. And so,
or accepted anywhere outside of their field, apparently.
Well, especially like 2%. You could get a better result out of just randomly picking people out of lineups instead of this. But you would have a better percentage at that.
Well, and back years ago, they didn't even do lineups. So they would literally just point to a specific person and say, "All right, check that guy's teeth and tell me if it matched up with this here injury." And so it wasn't even like they were selecting from a group of people. They were selecting from one specific person, and it was just a yes or a no kind of thing, which is a big problem, right? So like if you do a photo array nowadays, it's like flip through the book and point to the picture of the person who you saw do the crime.
Right.
But back in the day, it used to be, let me hold up one picture of one person and tell me if this guy did it, right? That was a really problematic way to do it because it was very suggestive. It was leading, right? And so you got a lot of false positives. It was very similar to the way that they were doing bite mark expertise and bite mark comparison. That's changed over time, but it's still a really bad and unreliable technique.
That's insane. They weren't even like, here's several people, pull their make impression marks from them, see which one matches up. They were just like, this guy, this is the guy we think it is. Make sure, find the evidence to back up what we think.
Yeah, that's not so far from the truth. That's pretty close. And they dress it up a lot, right? So there are these boards, right? The American Board of Forensic Odontology, and they create a whole book of techniques and methods that they have to follow. And the idea is that, they get on the witness stand, they can say, oh, well, I followed all the steps in the guidebook of the American Board of Forensic Odontology, and I'm certified by them and all this stuff, right? And it looks and sounds really official. It just happens to be totally hollow, right?
I could start a board today and just start certifying people in being an asshole. And look, I'm a certified asshole. I followed all the guidelines to be the best asshole I can be.
There you go. You might qualify. So we can fix that though. We can take the rule 702 from the federal rules of procedure and put it into our own and require reliability in order to qualify as an expert.
That sounds like a phenomenal step in the right direction there, along with everything else. I mean, the fact that you could, following the rule in Illinois, put a tarot card reader as an expert witness on the stand like that would be insane. Like palmistry, we're gonna bring palmistry into this too.
Well, and look, if you really tried to do it with a tarot card reader, I have a feeling that the judges would probably say. They'd probably find some reason to boot them, right?
Right.
But we shouldn't be relying on that kind of anecdotal stuff. We should have structural protections. But interesting that you mentioned this palmistry example, because not so long ago there was a science called phrenology.
Oh, where they'd measure your skull, right?
Yeah.
Yeah.
Measure your skull and look at lumps in the shape of your skull, and they used it to kind of justify slavery.
This guy's predisposition to be a psychopathic murderer because he has
because the frontal lobe is different size than okay. Mm-hmm. I know where that is. Yep.
I'd forgotten that I knew the name of that until you said it.
Yeah. Also the title of a great album by the Roots, but also a pretty terrible science.
Yeah. There's a lot of terrible sciences.
There's a lot of pseudosciences.
Yeah.
Of course,
as there's a name for it.
Of course, this guy was the murderer. Mercury was in retrograde that night.
And I'm an expert because I've been saying the same thing for the last 20 years.
Oh,
well,
geez.
look, and I mentioned this before, but in the 1690s in Salem, Massachusetts, when we were doing the Salem witch trials, happened in part because of a bad rule of evidence.
Yep.
Right? They allowed what's called spectral evidence, which was where witnesses would get on the stand and say, "Oh, I had a vision or a dream of the accused, and they hurt me in that vision or dream." And
they can do math. Right? They're witches.
Look, that was just the pseudoscience of their time, right? They were using a technique that was unreliable, but it wasn't so different from what we're doing now. It's just different name, different time. We're not that different from those guys. We can be, but actually.
Well, at least now we know if we tie them to some rocks and throw them in a river, they're not coming up.
Well, you never know. They could weigh the same as a duck.
Well, that's true.
I don't think that's a good method, but Monty Python sure did.
Yeah.
But the Salem witch trials came to an end. Here's the really interesting thing. There are two big differences between Salem witch trials. Their justice system is about as bad as one as you could possibly imagine. But two big differences between theirs and ours. One is the witches actually got trials, right? 97.4% of ours plead out. They actually got trials at a much higher rate. Some of them fled out too, but they went to trial. But here's the really interesting part. Salem witch trials ended in a total of 15 months because people were watching those trials, and after 15 months, they were like, "Hey, I think we're doing something really bad." I think we should stop doing it.
I think
Right?
we should stop lighting people on fire and throwing them in a river and
Stones. More stones. More stones.
And the American version, I think they just hung people in Salem. But the German version, I think that they were throwing them in the water and lighting them on fire.
Yeah.
But in America, they came to an end because a guy named Increase Merchant basically said, "Hey, I've been watching this, and I think two possible things. These witnesses, they might be telling the truth, and these people might be witches, or the devil might be playing tricks on the witnesses, and in fact, the accused might be innocent." In other words, he was saying we might be getting false positives.
Right.
Same issue we had with the DNA machine. Same issue we were having, false positives and false negatives. Same issues we were having with the DNA machine and bite mark science and hair follicle comparison and all this stuff, right? We're just calling it a different name, and we can learn a lot from the way that they fixed it in the past, which was doing it in public rather than pleading everything out.
That's yeah. I mean, didn't I tell you this was gonna blow your mind there, Brett?
I knew it happened. I wasn't aware that they can be used in court in such a fine fashion.
Oh, geez. Hey, you know what? We're going to take a break from seriousness now. Now that I've got you on record, we're going to ask this question again. Hot dog or sandwich, yes or no?
Oh gosh, I mean, the more I think about it, you raised it before. The more I think about it, I think it's a sandwich.
All right.
I think your hoagie, your hoagie comparison is a pretty strong comparison. But what about I got a question for you. What about a burrito?
It's a wrap.
Is a wrap a sandwich then?
No,
Why isn't a wrap a sandwich?
because it is not. It's a wrap. Hence, something is wrapped around it. It's a wrap. The sandwich is cut open. There's still an opening. Technically, if you smush it enough, you can make it a wrap.
I think the problem is, I think your difference there comes in with the wrap is whether or not it's a flatbread or not, the leavened bread.
Now that I think about this, I think this actually was a real case. If I'm remembering right, I think there was something that there was like a strip mall, and there was a sandwich shop that bought at least space in a strip mall.
Oh yeah, and it was
and part of their
exclusivity. Yes.
They couldn't have any competing sandwich shops. And then right next door, some kind of like wrap shop or burrito shop opened up, and the mall owner was like, "Well, it's not a sandwich." And I think it actually did get litigated. I can't remember what the result was, but there might be some case law on this.
I think I remember seeing that on Reddit at one point. Yeah, because it was there was an exclusive. It was exclusive that there couldn't be any more sandwich shops in the same strip mall, and then it was a burrito place that opened.
Burrito.
Yes, I remember that.
And you know what? I bet they got a lot of very useful discovery in that case.
Oh yeah.
You know what? Yeah.
Many depositions.
I would have to see the experts on that.
Yeah. Well, I guess you've kind of did an excellent radio lead in there to the adopt open file disclosures with your discovery.
Yeah.
It's almost as if you've done this before.
Oh, I'm getting better at it slowly but surely. But open file is this really interesting thing. So one of the things I mentioned was Brady disclosures a little bit ago.
Right. And the only Brady I'm familiar with being a firearms guy is the Brady Bill. So I was like,
this is a little bit different. So in a criminal case, you don't get a lot of discovery like we mentioned. But on the eve of trial, right before trial, the prosecutor has to turn over all evidence that fits both of two criteria. One, that it's material, and two, that it's exculpatory, which just means that it tends to prove that the defendant is innocent, or it tends to help the defendant's case, and that it does so in a significant way, right? And the problem with that is that we're really relying on the prosecutor to turn that stuff over, right? And prosecutors are humans; they want to win, right? And so we're relying on prosecutors to do something that is kind of against their self-interest in a way, at least their short-term self-interest. And as a result, we get a ton of cases of people claiming Brady violations, claiming that the prosecutor didn't turn over evidence that they were required to turn over. And it happens for a number of different reasons. One, sometimes they allege, pernicious motives, like, hey, they wanted to win, and so they buried this information. But sometimes the prosecutor just actually can't know what's material and exculpatory because they can't know what the defendant has, right? So
Right.
some evidence only looks material and exculpatory when it's combined with other evidence,
Right.
right? So, one guy says, hey, I saw the getaway driver drive off in his blue car. And the other party has information from the same witness saying, I saw him drive off in his yellow car. And all of a sudden, the fact that he made a statement about calling the car blue might seem material and exculpatory because it could call his ability to perceive or remember certain important facts.
Right.
It could call his credibility into question. But you wouldn't necessarily turn that over unless you had both sets of information. They fit together like a puzzle piece.
Right.
And so all of this is to say that it's maybe not such a good idea to rely on prosecutors to turn over stuff that's bad for their case or information that they might not have the full story on. So some jurisdictions have addressed this by doing something called open file policies or open file frameworks, where they say, instead of asking prosecutors to turn stuff over, we're just going to open their entire file, and it's going to be up to the defendants and their counsel to look through the file and figure out for themselves what they want to use. But all the information that's available to the prosecutor, with some exceptions, is going to be available to the defendant as well.
That seems like a
That's
really good approach, especially because, when you're dealing with prosecutors, a lot of times, especially when it's like, the state versus, those prosecutors are judged based on convictions. Again, like with the court and stuff like that. So they want to get that conviction.
Look, we're all human. We all not a lot of us are really hoping to lose, right? Even if it's kind of, even if we're people of great integrity, a lot of us will do subtle things to win, and we shouldn't have to wonder about that, especially when we have people's liberty on the line.
No,
So
definitely.
we can fix that. We can change that to make it a requirement that prosecutors turn over and provide access to everything in their file, and especially if we're going to have really limited discovery in criminal cases.
Now, you said that was open. Is it like with the open files disclosures? Is that still 24 hours, or like beforehand they have to give it over, or is it kind of more like when the prosecution gets it, they have to be able to see it?
Yeah, it's usually throughout. Basically, as soon as they get it, they put it into a file and it becomes accessible. So Brady disclosures, and different jurisdictions have a different time limit on this stuff, but Brady disclosures will sometimes get faxed over in a kind of a mountain of documents, like right before trial, 1 or 2 days, or a few days or something like that. But in open file frameworks, it's once the information goes into the prosecutor's file, it becomes accessible to the other side as well.
No, that sounds a lot more fair too.
Yeah.
Sometimes there's a time period for like redaction, right? If there's like a confidential informant, or if there's sensitive information that a stalker shouldn't have or something like that. But for the most part, accessible.
Nice. Yeah, that sounds really good too. So requiring judges to explain sentences. This is I've always wondered how judges come to their sentences, and I always figured that at some point they explain how that process works, and this is sounding like they don't.
Yeah, they frequently do not, and they actually have an incentive not to, because judges,
Of course
like
not.
prosecutors
Of course.
and other humans, judges don't like to be reversed. That's in general, they do not like to be reversed. And the best way to not get reversed is to provide as little opportunity to be reversed as possible. And so sometimes judges, when they sentence people, they say guilty, 25 years, next case, right? They don't have to explain how they arrived at 25 years, right? And in fact, if they don't explain, then they are more likely to not get reversed, right? Okay, so that's a big problem, though, because sentencing is actually a really error-prone process. It's pretty difficult. People make mistakes all the time. And if you don't explain the reasoning, if you don't show how you got that 25-year sentence or whatever it is, then it becomes effectively impossible to fix on appeal.
Right.
Because the defendant who was sentenced doesn't have anything to point to. Same kind of story as the landlord-tenant example, right? Unless you have an explanation or a record, then it's very difficult to fix on appeal. So the really interesting thing here is that this was a problem that the legislature actually spotted years ago. And the legislature said, look, if you're going to sentence someone to a felony, you got to explain the reasoning. You got to state on the record how you got the sentence that you did. And you got to speak it, you got to write it, something.
Right.
And they passed this law, and the Illinois Supreme Court said, no, you don't get to fix this. Only we get to fix this. Breach of separation of powers. And then they didn't fix it. And so it's still this way. Right?
Why? I mean,
We'll get around to it one day.
Is that kind of just like protecting your own kind of thing going on there, or is that?
You know, it's hard for me to say. I don't. If I'm guessing, I think it's probably less about kind of protecting their own and more a concern. Let me give you an optimistic view. Probably more a concern about slowing down justice. There's a massive concern about judicial efficiency is what they'll frequently refer to, judicial efficiency. And what they're really saying is, look, we have to conserve resources and move this thing along because our caseload is so high and our resources are so low that if we make requirements on the court, then we're not going to be able to handle the caseload in an expedient fashion, and everyone's going to pay the price. My personal view is that they are confusing efficiency and speed. And that actually they are catering towards speed, but it's inefficient because it lends itself to incorrect sentences and verdicts, and sometimes even more appeals on the back end. And there are all kinds of ways in which it's actually not very efficient. It's just fast.
Right. I actually run across that sometimes in my field, in the IT field. People confuse efficiency for speed.
Yeah.
Like, well, you know what? You know what I always say to them? If you got a car and it goes, 100 miles per hour, and it uses half a tank of gas, and then you got another one that goes 100 miles per hour and it uses a quarter tank of gas. Which one's more efficient?
My question would be, how big was the gas tank? What gear were you in? And what engine are you using?
But which one was more efficient?
Again, which gas tank? What engine? What gear are you in? See, you're talking to another guy
people
here.
like
The
car
expert.
analogies, man. People like car analogies.
Yeah, I know, and I hate them because that's what I've been doing all my life.
Oh, jeez.
It's like train A leaves the station at 6:15, train B leaves the station at 6:15. They're going to collide. Okay, great. Listen, missing a bit of information here.
Well, whatever.
So we can fix this one though. I mean, we can do the thing that the court said it has the exclusive authority to do, right? We can make that change.
So how does that tie in with mandatory minimum sentencing then?
Yeah, so there are these things called statutory ranges, and so if you're convicted of a certain felony, then the judge has to sentence you within a range, right? So
right.
Class X felony is I think 6 to 30 years, right? And what that means is you can't get a sentence below, for the most part, you can't get a sentence below 6. You can't get a sentence above 30, and that's, so you can kind of interpret that as a mandatory minimum. But the range is gigantic. It's a big issue because the range is so large that it leaves us vulnerable to bias, right?
Right.
You might worry that, a person that looks one way might be more prone to get a 6-year sentence for one crime, and a person that looks another way.
I'll just say it, the white guy gets a 6-year and the black guy gets the 30-year.
Yeah, we don't, like I said, we don't pull no punches. We can say that.
Oh, yeah. And I'm not trying to pull punches, but there could be not just race issues, but there could be gender issues. There could be geographic issues, right? Like, does someone get convicted who gets convicted in Cook County versus Cairo of the same crime? Are we in the same, how are we getting sentenced? Is it the same? So there's all, wealth and class and all these things intersect, right? And so
get rid of the board.
There's a way that the federal courts have dealt with this a little bit called sentencing guidelines. And they have these big ranges too, but they then create a narrow band within which you're supposed to get sentenced unless there's something called aggravating or mitigating circumstances that would demand or justify what's called an upward or downward departure from that narrow band. And so for the most part, people accused or convicted of the same crimes are supposed to be kind of in this narrow band to avoid bias and inconsistency so that you can kind of estimate where you're going to end up. We don't have that in Illinois.
Of course not.
Well, right. Yeah, why would we have that? Because that would make sense.
Oh, jeez. So
And that's, that plays a role in pushing things to guilty pleas too, right? Because what happens is you can go back into that 402 conference and the judge can signal, hey, I'm going to sentence you. If I find you guilty, I think an appropriate sentence would be 30 years. And then you can go into the hall and the prosecutor said, I'll ask for 6, right? And so it lends itself to greater coercion in that environment.
Right. It's as opposed to that narrow band where, you're going to be somewhere within 10 to 15.
Right.
Well, see, and that's the other thing, though. I mean, couldn't they just piecemeal together like you're putting together a value meal almost? Like, okay, you killed a guy, that's a minimum of 30 years. But if you did it with X weapon, that adds 5 years. X weapon, that's 10 years. Or if there was... So I know it gets really fuzzy with the more stuff that happens. And I know you can't just put one thing, but it just almost makes sense that you would start at some basic level and then kind of work on it expungingly from what happened.
Yeah, there's some ways to kind of juke the system, right? Where sometimes you'll see someone seems like they do one thing wrong, and then they get like 50 charges against them, right?
Yeah.
And
piling on.
Putting on my cynical hat for a second. One reason you might overcharge someone or use every charge that you possibly could is to kind of be able to threaten someone into a guilty plea. And then even though you have these sentencing guidelines, you can do a number of things, which is one, the prosecutor can say, oh, but I'll drop, charges 1 through 10, right? And then you're kind of dropping the number, or you can say, I'll ask for, concurrent sentences so it's not a perfect solution.
Throw 20 on, even if they go to court, at least 4 or 5 is going to stick.
Right.
Right. I mean, so you see, you'll see people dropping charges with some regularity. So sentencing guidelines by no means a perfect solution, but in terms of trying to get us to a place where we're creating more consistent sentencing, it's at least one tool we can use.
All right, we're coming up on that hour point, so that's usually when we cut our shows off. But if you want to push past it, and if you still feel like talking, we'll keep talking.
Let's do it.
All right. So we just kind of talked about the bias in sentencing there a little bit in there. We kind of lumped that one in. We've got to protect against judicial corruption, and you talk about conflicts of interest and calling themselves out for recusals. So nobody looks at when somebody goes, hey, there's not somebody who goes, all right, you might want to recuse yourself from this. There's no double check on that.
We just kind of had that though. It was at the federal Supreme Court. The last guy that resigned.
Oh yeah.
Yeah. So both in the U.S. Supreme Court and the Illinois Supreme Court, we have something called auto recusals, which is it's up to the justices themselves to determine when they should recuse from a case, whether they should step aside and not take part in it because they have some good reason not to do it, right? The difference is in the U.S. Supreme, and frankly, I don't think it's a great idea even in the U.S. Supreme Court, but it's an even worse idea in our appellate and Supreme Courts because we elect our justices, and so there's a lot more opportunity for conflicts of interest to creep in, right, through campaign donations or stuff like that, right?
Yeah, most definitely.
Right. So as it stands, appellate and Supreme Court justices, they really are the last check, right? If someone says, hey, I think you have... Actually, let me take a step back. If we were in trial court in Illinois, and you think the judge you got has a conflict of interest, right? Maybe their life savings are invested in your opponent. You can do what's called an SOJ, motion for substitution of judge, and you can say, hey, I think you have a conflict of interest, and you shouldn't be able to decide this case. The person who gets to decide whether they have a conflict of interest is a different person than the person with the alleged conflict of interest. That's a good idea. That's a really good way of doing things, right?
Right.
But it is not how it works in the appellate and Supreme Court levels. At the appellate and Supreme Court levels, it's up to the person with the alleged conflict themselves to make that determination, which means we have to trust someone with an alleged conflict to tell you that that they have a conflict, which to me seems like a conflict.
So okay? Even if I find out that you have a conflict, bring it to your attention, you can still say, no, I'm good. I'm going to sit right here.
That's correct.
Wow. Oh,
right? And this this has happened before, right? Like this is not just a hypothetical. This is something that actually plays out. And so it's the good news is industries in every other sector have dealt with this, and our own trial courts have figured out a way to deal with this, and so we can do it too. It's not that big of a deal. We just got to make that change.
That the fact that somebody can get called out on having a conflict of interest, and then they just no,
I'm good here. Yeah, no, this will work out. No, I mean at that point, of course, obviously you could appeal it, and then you go higher up or whatever. But I mean that also adds on to the time because these people,
could you appeal that at the appellate level where you said that they make their own decision?
Yeah, so let's say you did it at the Illinois Supreme Court, right?
Right.
And where are you going to appeal from that?
Well, other than that, it'll be going to federal, right?
Right, and they've done that, and actually, that the U.S. Supreme Court refused to take the case. So there are potential avenues, but it doesn't mean that you're actually going to get a case heard. And also, it takes a lot of resources to do that.
Right. Man, that's wow.
So okay, so let's bring this down here to a McHenry County level here. Okay, you go to say the city of McHenry Court, and you find out that the judge has a vested interest in the paper company that they wrote the ticket on, and you ask him if you can have a different judge. He says no. He sends you to whatever. You have to pay your fine. For price referencing, we'll just say the case would cost you $100,000 to bring it to the next level, which would then be a circuit court, correct, in Illinois?
So I don't know. I'm not exactly sure how this would work actually, because typically, so you go circuit court is the trial court level, and then you go to an appellate court, and then you go to a Supreme Court. But I'm not sure how your city courts work.
I don't think we actually have a McHenry City Court, do we?
The city of McHenry, I think, does. But it's just traffic court, I think.
Right.
But, yeah.
All right.
But that's what I'm saying. I know McHenry does.
Yeah, I wouldn't want to give you incorrect information.
No. I'm just saying, but yeah, if it were to go like that, then if it went from the city, it would then go to the circuit and then appellate.
You got to remember, lawyers are not big fans of answering hypotheticals.
No, I get it. I know.
Especially when it comes to law.
Right.
Because then somebody might hear them and then cite them and go, hey,
right.
I heard from this lawyer that this is okay. That just opens up a big can of worms that nobody wants to open. Am I wrong?
I think you nailed it.
Yeah. He's not going to answer that question, Mike.
Racist jury selection. This is an interesting one.
Yeah. So there's jury selection works by starting with a pool of jurors. Actually, it starts even before that. You start with people who are registered to vote. You pull from the registry, and you ask people to show up for jury duty. And when they show up for jury duty, they become part of something called a jury pool, or sometimes it's called a veneer. And then you start
thin veneer.
A thin veneer, that's right. And what you then do is you start picking people off, excluding people from the veneer until you're left with the number of jurors that you need in order to move forward to trial. And historically, we've had really big problems with that because we have trouble getting juries of peers when it comes to race. Or said differently, oftentimes if there's, for example, a black defendant, the prosecutors will sometimes try and eliminate black jurors, exclude black jurors from the pool in order to get the whitest jury they possibly can, kind of preying on notions of racial bias. There's been some research on this in southern states to show that that's going on, and there's some reason to believe that it's going on elsewhere as well. I think ample reason actually.
I think that falls under the common sense thing that's going on.
Wait, the what?
So there's a tool that we have to fight back against that, and because excluding a juror based on race is illegal, you're not allowed to do it. And the tool to challenge that is called a Batson challenge. You say, hey, I think you just eliminated all the black jurors because you want to get the whitest jury possible, and I'm going to issue a Batson challenge. Okay. So the problem with Batson challenges is that the next step then is for the attorney who excluded those black jurors to provide a race-neutral reason for their exclusion. And that race-neutral reason can be super weak. Like they can give all kinds of excuses. They can basically give any reason so long as it's not because they were black, right?
Right.
And what that means is that Batson challenges are extraordinarily difficult to win and extraordinarily easy to juke. Right. So it's toothless, basically. Not totally, but largely toothless. And we are therefore not protected against racist jury exclusion, jury selection.
I didn't exclude him because he's black. I exclude him because he has brown eyes.
And the fact that I could barely understand what he was saying.
So I think we need to start experimenting with ways to create non-toothless tools to fight back against racist jury selection. And one of the ideas is, well, have you ever seen the show The Voice?
Yeah.
Vaguely familiar with it, yes.
Kind of like The Voice, right? So it just turn their chair so they can't see the jury pool. Not perfect, because sometimes you can detect race in other ways that aren't just physical appearance, but better than nothing and pretty easy to implement and worth experimenting with. And actually, the area that there's precedent for it as well, which is in mafia trials, they started doing these things called innominate juries. And the way it works is basically the veneer, you get to know information about people in the jury pool. You get to know their name and their address, and then you can do research on them. But in mafia trials, people were worried that people in the jury pool would get hurt if the mafia got a hold of their identity and address, right?
Right.
And so they started doing these innominate juries where they were not allowed to know the name or address of the jury pool. So they shielded the identity of the jury pool. Well, we can do the same thing and just shield the physical appearance. And look, to be totally frank, I don't know if this would work. I think it's just worth experimenting and seeing whether it works, because it's such a serious issue that I just don't think we can just give up on it. We did Batson, and it just didn't work very well. And it seems like we've kind of thrown up our hands and haven't done much to make it better. And I think we need to still work on it. And so this is just one idea, and I think we need to start to experiment with it and see if it works.
Well, we were just going to add in here, I think you can also put in like the that voice changer part of it.
Yeah, that's exactly what I was going to say. Set it up just like those guys that appear on the news and don't want
it's all
their
blacked
ID.
out, and they just like all talk like this, and then they all sound exactly the same.
That's right.
Now that would would make sense.
Seems like it would help.
And well, like I said, it would seem to make sense.
Right.
You don't get the scene. I mean, I know you get at that point where jury by your peers, and you have to face, you're able to face your accuser and all that good stuff. Which, again, while you're choosing, but when you're choosing the jury, exactly, it has nothing to do with it. So whether or not you know who they are, or what person or what race or whatever, they're legally able to be a juror. So
right.
That's right, and you still get to ask them questions and probe and make sure that they don't have any conflicts of interest themselves, and you just don't get to see them. That's it.
And make sure that they're not going to mention those two words that'll instantly get you kicked off of most juries.
Jury nullification.
Oh yeah, there you go.
We've found out that there's actually people that are scared about those words around here. So. Yeah. Which is weird because, you say it and they just kind of look at you sideways, and then you're like, yeah, it's all about this. And then they're like, whoa. Wait a minute.
So I think we only got 2 more points if you want to hit both of them too. We got the remote court appearances, which I think is a no freaking brainer.
Hell yeah.
In fact, I've got a friend right now who's been traveling back and forth to Ohio because he's like, hey, can't I just do this over Skype? And they're like, nope.
Yeah. So, and actually the way I arrived at it was a little bit different, but I think that's actually super common what you just described. Not just interstate, but just a lot of people are really far from the courthouses. But the way I arrived at it was I was talking to a group of folks in Cook County who had just gotten laid off from a factory, and they were all undocumented. And I asked them, how many of you have ever experienced wage theft? And every single hand went up. And I asked, how many of you have ever sued the people who stole your wages? And every single hand went down. And it's because they won't set foot in our state civil courts to sue the people who steal their wages or abuse them, because they're afraid that ICE is there.
Right.
They're afraid that immigration is there and that they'll detain them and deport them. And it's effectively like a subsidy to wage thieves and abusers, right? Because those folks know that the people that they're stealing from and abusing will not set foot in civil courts against them, right?
Nope.
And they prey on that. And so we got to figure out ways for those folks to bring cases. And there's a number of different ways they can do it. But one of them really should be to embrace the notion that not all of us have the privilege to be able to physically set foot in a court. Maybe it's because, we're undocumented. Maybe it's because we have a disability, or maybe it's because, we're a caretaker. We can't leave someone, a child or a loved one who needs our assistance. We can't take time off from our second or third job to spend a whole day in court hoping that the judge calls my case on time, or we live in a rural area where it's far from the courthouse. All of these things make it very difficult to set foot in a court. And the great news is we have technology that makes it so that we don't have to set foot in court. We can do a lot of things remotely. And in fact, some jurisdictions have already done this, but it's not proliferated throughout our state. And I think we need to start really utilizing technology and getting us up to date with that for convenience reasons, but also for reasons related to access to justice for people who are really vulnerable because of it.
You were talking about speed and efficiency of court. How speedy and efficient would it be, not only for the court but for the individual? Let's just bring this down to the lowest thing here in this county or basically in the country is traffic court. You don't got to take a whole day off from work in order to go show up at traffic court. You just dial in with Skype, get in the queue, and they call you up.
Yep. And there's also a major issue with affordability, right? In many cases, you're paying your lawyer for travel time.
Right.
Right. You're paying your lawyer to sit in court and wait for your case to be heard. That makes things really expensive. And a lot of people won't even access our court system or try and get a legal remedy because they know it's just too expensive.
Yeah, it's like having health insurance but not going to the doctor.
Right.
Yeah.
Because you can't afford the deductibles.
That's right. So look, everyone knows that the justice system is extraordinarily expensive, and in many cases prohibitively so. We really have to start addressing that, and I think technology is one of the ways we can do it.
That sounds phenomenal as well. I mean, where did you come from? There isn't a thing that came out of your mouth that I've said like, oh no, that doesn't make sense. That doesn't make sense. Like, we need more people like you.
I appreciate it. I appreciate that.
Help restorative justice courts flourish? Or did you have something more?
No.
You were looking at me funny, like why the hell are you moving on, Mike?
No.
Give me a chance to talk.
I was actually kind of waiting for you to mess up either the restorative or flourish.
Yeah, because I can't talk today, apparently.
So restorative justice practices are a method by which both alleged perpetrators and victims, as well as community members, get together and get into what's called a peace circle. And they kind of talk about what happened, what the pain of it was for the victims and the community, and start to develop a plan for restoration, both for the victims, for the community, and ultimately for the perpetrator as well, so that they're not in a position where they feel the need to do these kinds of things, right? To commit the crimes they initially commit.
I guess let's get a quick explanation on what a restorative justice court is, because I don't know what that is.
Yeah,
I'll raise my hand. I'm ignorant here. Let's go.
Yeah, so there's a good reason you don't necessarily know, because there are very few of them, and they're just starting to come up. And but what you might have heard of is like specialty courts or pretrial diversion, where let's say someone gets convicted for heroin possession or something, right? Something, a nonviolent.
Oh, like the
minor,
drug courts or the minors courts
Exactly.
that they have in the county.
Right, and where they say, look, rather than kind of embroil you in the criminal justice system and send you to prison and all this stuff, let's instead say, here's a plan for addiction treatment, and if you complete this plan, then we'll drop charges, and we won't have to end up spending a ton of money imprisoning you, right? And you'll be better off, and the community will be better off, and that kind of thing, right?
Right. Okay.
So restorative justice courts are similar in that if you meet certain criteria, then you can go, rather than to a normal court, than to a restorative justice court, where you have what's called a circle keeper, the victim or victims and members of the community. And instead of having a judge or a jury and a prosecutor, you all communicate with one another directly. And it generally involves the alleged perpetrator allocuting, kind of talking about what they're alleged to have done, basically fessing up to it. The victims talking about how it impacted them, the community talking about how it impacted them, and then establishing a plan for restoration of all parties involved. So here's the problem. And if they proceed with that plan successfully, then charges are dropped or it doesn't appear on the record.
So kind of like a court system of the 1800s.
That may be so. I don't know enough about it to say, but
well, it definitely sounds like a portion of this that's required is that the person who is the perpetrator needs to acknowledge that they've perpetrated, that they need to be seeking that atonement and acknowledge. So I mean,
bingo.
Why bother putting them through the whole crazy court process if they already know they did wrong and they've admitted it?
Well, here's why that's really interesting, because that absolutely is part of it. And there was a group, there's a large coalition who proposed a rule to the Illinois Supreme Court saying, look, we're asking people to basically fess up in these restorative justice courts, but we're doing it in a way where their communication is non-privileged. Meaning, if they then don't, if they say something that could, whatever they say there could be used against them in court down the road. And that's a big problem, because restorative justice courts rely on openness and forthcomingness in order to work. And if you think that something you say can be used against you down the road, you may not be so open and forthcoming.
Yeah, you're not gonna say nothing. You're just gonna be like, nope.
Ain't saying nothing.
Right. And so, unfortunately, the Illinois Supreme Court rejected that rule. And so it continues to be the case that things that are said in those peace circles, may be used against people. And thus far as I can tell, they haven't been. But my concern is that at some point it may, and then it will really kind of turn back a lot of the progress that we've made in promoting restorative justice courts. So I think we should revisit that rule change and really reconsider whether those should be privileged communications.
Yeah, it seems like it's kind of required for it to work. If we're going to be open, we got to be open, and this can't be used against you. Otherwise, you're not going to be open.
And like most of anything else, it's not a matter of if, it's just a matter of when.
Right. It's not a matter of if it'll be used against you. It will be. It's just down
when.
the road.
Yeah.
So that's my concern, and I think the good news is there are a lot of folks who I think would really support that rule change, and my hope is that we'll have another opportunity to revisit it, and that I'll be on the court when we do.
Awesome. I think we've hit all of your issues now, unless I've missed one.
No, that's everything we got. We got some more stuff coming up on the website down the road, but for now, that's what we have up, and maybe we can talk about more of them down the road when we get more stuff up.
I'd love to have you back on. This has been like you are in the top 2 of the most informative people we've ever talked to.
Who's the other one?
That would be
Carolyn Schofield.
Yes, Carolyn Schofield.
She ran for county board in our county.
The amount of knowledge that she had about everything that goes on in this county was crazy.
Yeah.
Well, I got to check out that episode.
Yeah, it was very good. But is there anything else you'd like to add in that isn't on these issues things? Anything we missed? Anything that I didn't pay attention to or bring up that you'd like to, or any small filibuster you'd like to take? Now's the mic is yours.
Well, yeah, I'll say, look, we're running to make our courts less biased, protect ourselves from corruption, and I, throughout the course of this interview, I talked about a lot of the ways in which our court is experiencing injustice or is vulnerable to injustice, and sometimes it can seem like we're kind of condemned to this fate because this is just kind of how it is. But I really want people to feel not that way. I want people to feel empowered, because really what I'm trying to do is not point out all the ways in which our court system is broken. What I'm really trying to say is, here's specifically how it's broken or how it's flawed. And when we know how it's flawed, that means that we can fix it. Once we identify those issues, it means that we can identify solutions. And I want people to feel empowered and know that we can demand more of our judges and justices, especially the ones that have a policy-making role, and we should, because we're the customers of the court. And it's really important that we make progress and protect ourselves from problems that have been going on for a really long time, and that we demand more of our judges and justices, and we demand a court system that's protected from bias and corruption. We can do that, but we need a friend on the court, on the Illinois Supreme Court, and I'm trying to be that friend. And so if you're interested in helping, we can do it in a number of different ways, but one of the best ways is on March 17th, if you're in Cook County, come out and vote, and I hope you'll vote for Daniel Epstein. But there are many ways to support. Tell your friends, likes, shares, all that good stuff. But I'm really, I feel really honored to be able to share some of this information and start something much bigger than one election, really a movement about procedural justice. And I hope it's something that can really spread far and wide. I appreciate you guys for helping me do it.
No, we appreciate you taking the time out to come talk on our little podcast here.
Our little corner of the world.
So you've got a couple of events coming up here. That you've got a Meet the Candidate event in downtown Evanston on October 20th. So if anybody out there would like to meet Daniel here and
or ask him another question that we have not.
Yeah, like is cereal just cold soup? You can see him down there. There is another event that's coming up a little bit sooner. I'm going to mention it anyways, even though I may not get this out before that. Because what is today? I don't even know what today is.
12th.
Today is the 12th. On the 16th, I think I might be able to get this out before that. You've got a Illinois Supreme Court Candidate Forum at ACS Chicago, and both of these events are up on his website. And I'm sure there'll be some other ones up there, and we'll make sure to link to his website below the video here. So we'll have links to his...
we'll have everything. The website, the Facebook stuff.
Yeah, we'll find his Facebook. Oh, look, there's a button for his Facebook. We'll put that up there, too, for you. And then... So thanks for being on the show, and I wish you nothing but the best of luck. And if there's anything else we can do to help you on your way, feel free to reach out to us.
Yep. I sure will. Thank you all so much, and I hope folks will tune in to EpsteinForSupremeCourt.com and come out to one of our events soon. And hope I can come back and talk to you guys soon after we get some more of these issues up on our website. Awesome.
You hang just for a moment. We'll finish up with the end of the episode, and then we'll say thank you off the air.
Sounds great.
So I think that just about wraps it up, doesn't it, Brett?
That, I believe, completely wraps it up.
Yeah, 100%. All right. So, again, I'm Mike Toller.
And I'm Brett Bader.
And this is Don't Panic, McHenry County. Don't do anything I would do.
Or me.